This employment law video is on TUPE. Under TUPE, when there are business transfers and certain conditions are met, employment contracts, rights and liabilities are transferred with the businesses too. When does TUPE apply? The first type of business transfer is where the business or part of the business moves from an employer to a new owner, or there is a merger. There must be an economic entity, a transfer of an economic entity, and the economic entity has to retain its identity following the transfer. The second type is service provision changes. This happens where a service is provided in-house, such as answering calls, and it's outsourced. Or a contract is awarded to a new contractor, or the service is brought back in-house. The activities carried out before the service change must be fundamentally the same activities as those carried out after the service change. And only the employees who are clearly providing the service are protected. TUPE does not apply where there is a change of supply of goods for the business, or there is a single event or short-term task, such as using caterers for a corporate event. TUPE does not apply to a transfer of shares, transfer of employment contracts, rights and liabilities. When TUPE applies, the employees of the old employer automatically become employees of the new employer. They maintain their continuous service and should also have the same terms and conditions. Also, the new employer is responsible for any failures of the old employer to observe the employee's rights. Employees are able to object to transferring to the new employer. If the employee objects, no notice is required and the employment ends on the transfer date, changing terms and conditions. The law generally prohibits employers from harmonising terms if the sole or principal reason for the change is the transfer. Employers can improve terms, such as increasing holiday entitlement, but any changes would have to be agreed. The new employer is able to change terms and conditions if the reason is an economic, technical or organisational reason, an ETO, involving changes in the workplace. This could cover reasons to do with how the business is performing, processes, or the structure or management of the business. Dismissal. A dismissal will be automatically unfair if the sole or principal reason for the dismissal is the transfer. If the reason for the dismissal is an ETO reason, then the dismissal could be potentially unfair if the employer has not followed fair procedures. Information and consultation and employee liability information. Employers are required to inform and in certain cases consult with trade unions. And if there are no recognised trade unions, elected employee representatives. The old employer is also required to provide certain information called employee liability information to the new employer. For more information on obligations and details of TUPE, please visit my website. That's my video on TUPE. The usual caveat is that this video is for guidance only and should not be relied upon for specific advice. And if you're interested in receiving notifications on other employment law videos, do subscribe to my channel.